And court does call the case of the people of the state of Michigan versus Zachary Radcliffe.
Good afternoon, Your Honor. Jacob Kennedy on behalf of the people.
James Thomas on behalf of Mr. Radcliffe.
I don't know, Johnny, on behalf of Mr. Radcliffe, Your Honor. I do believe that we filed an appearance on my behalf of Mr. Radcliffe.
Before this hearing even begins, Judge Simpson's courtroom feels tense. The defendant, Zachary Radcliffe, faces not only legal scrutiny but also public judgment. Supporters are present, letters of backing have been filed, and emotions are running high. This isn't a routine procedural day. It's the fallout from emotion that stirred up unexpected controversy. From the very start, we see how courtroom decorum collides with online chaos. Doxing, public exposure, and emotional crossfire now hang over a case that's supposed to be about justice, not social warfare. What's remarkable is how calmly Judge Simpson walks the audience through the chain of events, document filings, suspicious public behavior, and potential witness interference. He's methodical, but make no mistake, this judge is laying the groundwork for serious accountability. Watch closely, every word here foreshadows how law and digital culture clash inside this courtroom.
Yes, we have the appearance. Mr. Radcliffe is now present in the courtroom. And sir, if you could say your name so that the camera comes toward you so they can see that you're here.
Yes, Zach Radcliffe.
All right. So he is present in the courtroom. Just by way of introduction in this case, so that everybody's up to speed is in terms of what happened on last Friday. What day is that? The 7th. Well, even before then, counsel for defendant had filed a motion to dismiss, filed a supplemental pleading that contained letters of support for the defendant that the court reviewed. That came through as a filing to the court. On the date of the motion, well, on the date of the hearing, certainly there were people in the courtroom that were agitated. Certain people came to our attention just in terms of their actions and other things, both my attention as I was looking out at who was here, as well as my bailiff's attention. There was one individual that my bailiff had reported to me that he spoke to just to make sure that there was nothing that was going to occur. Subsequent to, so that was on a Thursday, and I don't believe that it was the next Thursday. I can't, my dates are a little off a little bit here, but anyway. At that hearing also, Mr. Thomas presented additional letters of support for the defendant. I received those at the bench. They did not sort of come through and were filed as that supplemental report was. I retained those in my office file because of the way that they had come to me. I had taken a break during that proceeding at some point and reviewed those. That next day, the same individual that my bailiff had spoke to, as well as the person that had come to my attention, it was reported, well, we found out it was that same person eventually, but my clerks had reported to me that someone was at our front counter seeking to get the information regarding who had supplied the letters of support, specifically the ones that Mr. Thomas had presented to the court in court that day.
The moment Judge Simpson reveals that someone showed up at the courthouse demanding to know who wrote letters supporting the defendant, it becomes clear this case has left the courtroom and entered the wild arena of public outrage. This isn't just curiosity. This is intimidation disguised as transparency. It's one of the most dangerous byproducts of modern trials. When private citizens become online targets simply for speaking up, the judge's concern is justified. His responsibility extends beyond rulings. It includes protecting participants from harassment. Viewers, think about it. Should supporters of a defendant risk exposure just for expressing loyalty? Or is this the inevitable price of a public justice system in the digital era? These are the ethical fractures this case now exposes, and Judge Simpson seems determined to seal them before they spread any further.
That raised an alarm on the court's part as to why someone would want that information. I guess so that the record is all clear, I then got the file from the clerk's office, set a hearing, had my office email counsel, set a hearing regarding a protective order or something regarding those particular activities.
At this point, the judge's patience gives way to concern. He has ordered a hearing over what amounts to digital stalking. When people begin targeting supporters or victims outside the courtroom, it erodes public confidence in the entire judicial process. The audience may not realize it, but this protective order hearing is as important as any verdict. It's about safeguarding the very structure of justice. Notice how Simpson frames it carefully. He isn't accusing anyone, but he's signaling to both sides that the court won't tolerate interference. This is where his authority transforms from procedural to moral. He's telling everyone in that room directly and indirectly that the law can't function amid chaos. Would you agree that digital harassment should be prosecuted like physical intimidation? Let us know in the comments, because this case raises that exact question.
And basically held the file so that until we could sort of resolve or try to resolve this issue. We were informed, I don't have the entire email, certainly counsel could speak for themselves. Upon setting the hearing, I think Mr. Thomas had indicated that he was looking into things as some of the people, and Mr. Thomas, certainly correct me if I'm wrong on this, that had supplied those letters, that they had been doxxed in some way and their information in some way disseminated or provided. The prosecutor's office also made me aware of, after that, but prior to the hearing, that there are individuals, and I'm going to say it in this way, that could potentially be viewed as acting in concert with the defendant. And when I say it that way, I'm not saying that they are. I'm just saying it could be viewed that way. We're contacting victim or victims' families in regard to this case. And so that was the last kind of thing. There was certainly an email regarding certain discovery issues and other things that went back and forth. But the purpose of the court's hearing today was to hear from counsel and to try to figure out, if we can, a way that this can be alleviated, and use what powers the court has to try to stop it from occurring while everybody proceeds to this process. All right. I say that all as a preface. That's kind of where we are. I think both sides kind of do most of that, if not all of that. And I'll do that. So, Mr. Thomas, maybe it makes more sense to sort of hear from you, I guess, because you were looking into some things in regard to it. So,
Yes, sir. So I'm going to leave the names out for purposes of, I don't want to put them on the record, but I was contacted by supporters of my client, obviously, and I had learned that there were names that were being doxed from the letters that we submitted as an attachment to our supplement. Obviously, it rose concerns because I didn't learn of that till obviously after the hearing had already been conducted. Had I thought about it, I probably should have submitted them under a protective order in the first place. So that's kind of on me that I didn't do it that way. I just didn't think that it was going to rise to the level of where we're at right now with with the people on the other side of this equation. To address the court's concerns regarding whether these people are in concert with my client or not, I can assure you that I've had meetings with most of the people that are involved, the ones that have been coming to the normal court dates, and I have specifically told them, do not talk to these people, do not reach out to them, do not call them, do not email them. They all know, the family knows, and everybody else knows not to engage with them in any sort of way, and they have not. We have not gotten any reports from anybody that anybody from the defendant's side have contacted anybody on the prosecutor's side. Now, that's not the same that we're getting from the other side. Of course, we're getting messages from people, and I really don't want to go there because I'm not personally involved in this, Judge. I'm the lawyer. I have a job to do to defend my client. I'm not personally involved with the emotions that are involved in this case. I'm a lawyer. I'm a lawyer that protects the Constitution and my client's rights. And so that's how I feel about it. That's what I've been engaged to do. I am technically a mercenary to defend my client, and that's it. The emotional stuff that is going on between the families and of the victims and the family of the defendant are, to me, those are things that should not be in the courtroom. Obviously, at some point, I'm going to address those things, because if we end up going to trial and there's noises or gasping in the crowd, I'm going to move for mistrial, and I'm going to do whatever
I don't need to know your trial strategy, counsel. I really don't.
No,
that's not what I'm here for. I'm not here to talk about you. I'm not here to talk about anybody. I'm here to try to deal with making sure that things don't come out of this that I don't think any of the parties here intend. And so when I set this, my issue was to certainly listen to counsel as to how to do things. There is a individual, and what I will do is I will have my staff, and rather than put the name on the record or the phone number that's contained in here, can we scan and send? I realize I only had you, but
no, it's okay. Can
I scan and send this to Mr. Thomas, and we'll address it?
You want this done right now?
Yeah,
yes.
I want that done so that we have that.
If I may just say one more thing about these letters, they've been put out on social media, and they're being used specifically to attack the people on social media and the church that my client's father is the pastor at. So they're doing it for other reasons other than just to retaliate. They're doing it to try to punish them economically, socially, and everything else, trying to shame them. So it goes a lot deeper. So do I think a protective order needs to be put in place by the court, for this? I absolutely. Again, it's your choice. You can do whatever you want. And again, I'm not, personally, emotionally involved in this, but obviously, if the court thinks that, this has gone above and beyond what needs to be done, this is a one defendant that there's allegations against, not the family, not the church, not the pastor.
Defense attorney Thomas is walking a fine line here, trying to protect his client while acknowledging that something sinister is happening outside his control. His statement about supporters being doxxed shows the collateral damage that unfolds when personal loyalties collide with social media. He calls himself a mercenary for his client, a sharp, almost cynical description, but that honesty reveals his professional separation from the emotional mess surrounding this case. Still, his frustration seeps through. He knows public exposure can poison any trial before it begins. The key takeaway for viewers' courtroom advocacy doesn't end with legal arguments anymore. It now extends into managing online narratives. When the defense has to worry about people being harassed for writing a letter, that's no longer a legal issue, it's a societal one. Would you side with the defense here, or does accountability outweigh privacy?
And for these people to go and take these letters that people that support my client has got no bearing on those other things. They're doing it just to be ugly. And so I think the court can use its discretion to put a protective order in place against that, if the court so deems. My other concern is that those letters I gave the court, I did not file. And so I told the court that I was going to file them until I learned about the doxing, and I decided I was going to hold off to see exactly what was going on social media. So I don't know how you want me to address that. If you want me to
Are you
try
talking about you're talking about the letters that you presented in court?
Yes, sir. The ones that I
Okay.
didn't have time that we submitted, that I got at the last minute. So there's nothing in the record other than you saying I got them, and obviously the names and all that are not part of the record. But if you want us to do it under a protective order, to submit those other letters that I gave you, so they'll be part of the file but be protected, I'm happy to do that if that's what the court wants me to do.
Understood. Mr. Kennedy.
Yes, Your Honor. Just a couple of things. As the court knows, I, as well as Ms. Reiser and the rest of our team on this matter, were not aware of any doxing taking place until just now, which has been indicated by Mr. Thomas. I do want to make sure that I'm clear as to what has actually transpired. If there are these letters that are being placed on Facebook, of course, I am concerned about people's personal information being placed out on social media platforms. I will say, however, that simply being present in the courtroom would indicate to others, I mean, we were all there on the night of the hearing, being present in the courtroom and sitting on a specific side indicated to the public and those who were within that proceeding who was being supported. And therefore, those members of the courtroom going out and indicating to others that so-and-so was on his side, so-and-so was on our side, is simply something that I don't think can be controlled. I don't think that it can be controlled in terms of the community of Saline, in terms of the greater Washtenaw County community. I think we all are certainly an understanding that this is a case that has deeply impacted the community, has deeply impacted this church, and has deeply impacted the victims and the defendant. So I understand that protective order on the letters will certainly prevent this personal information that is placed in these letters from being further disseminated to the public. And in safety concern being of the utmost priority, I would agree with Mr. Thomas, and I would agree with the court. I believe that a protective order would be warranted, but I don't think that it's almost as if this has gone to the point of no return almost. Simply being physically present in the courtroom and sitting on an individual's side indicates a support, and we just simply cannot control what people are going to say within their own community about those other individuals. So
Here, the prosecution acknowledges a painful truth. Control over community discourse is impossible. Once a case enters the public sphere, it takes on a life of its own. The prosecutor agrees with the defense about protective orders, yet also admits that perception itself can't be legislated. It's a strikingly honest moment. Both sides, for once, united in concern rather than conflict. Judge Simpson now stands at the crossroads between free speech and public safety. This is what makes courtroom drama real. The legal system wrestling with problems it was never designed to solve. As viewers, this is the point to ask yourself, where should the line be drawn? Should the court intervene in social consequences, or should justice stop at the gavel? That question defines the emotional heartbeat of this entire hearing.
I am concerned about the doxing. I would ask this court to please make me aware if there's anything else that has happened. And as I've indicated previously, we were unaware. I've spoken with the officer, spoken with our victim advocate, and they were also unaware that any doxing had taken place prior to this week. So all that is to say, would be in favor of a protective order in order to secure the safety of the community. And I would like to say thank you to the court for bringing this to our attention. It is indicative of the court's desire to make sure that the community is safe.
And here's what I'm going to, and having listened to both sides, here's what I'm going to do, unless I hear an objection. Mr. Thomas, the supplemental document, the attachments to the supplement, the letters that were contained, I'm going to separate those out. I'm not going to strike them certainly from the record. But what I'm going to do is I'm going to place those as well as the other letters in a confidential portion of the file that won't be released to the public if somebody comes to look at it. I'm basically going to put a sort of check system in place that if somebody wants to look at it, it should come to the judge and then make a determination.
Judge Simpson is now doing what strong judges do best, taking control. He outlines a practical, airtight safeguard to keep sensitive documents sealed from public reach. This isn't censorship, it's preservation. By restricting access through judicial review, he's reasserting that transparency doesn't mean exposure. Every responsible viewer should understand this moment. Simpson isn't hiding evidence. He's protecting real people from real harm. The court system depends on honest participation, and when fear of doxing or retaliation looms, witnesses and supporters go silent. This move ensures they won't. Legal commentators often overlook that the best rulings aren't always loud, they're protective. Here, Judge Simpson turns procedure into protection, proving that order and empathy can coexist inside the law. Would you trust courts more if measures like this were standard everywhere?
So if for whatever reason you needed a copy of it, or somebody from your office needed a copy of it, you wouldn't be able to walk in and get it, but you contact the court, we would be able to get a copy to you. That way, I think because I have to balance making sure that the record that's there is complete, with the same time not making sure that individuals can't walk in. So that's the first thing that I think the court's going to do. I would also indicate to counsel that and I will draft an order to that effect as to what specifically I'm going to do. But I would also indicate to counsel that if there are other documents or other things that would contain personally identifiable information, almost defined in its broadest sense, that you provide a copy to the court if you are filing it, that you redact that information from what is filed.
The judge's next instruction is a blueprint for digital age courtroom ethics. By ordering all future filings to redact personal identifiers, names, phone numbers, emails, he's bringing 20th century legal tradition into the 21st century of online exposure. This isn't bureaucracy, it's evolution. Think about how many viral clips you've seen, where a defendant or witness's personal info leaks, and suddenly, strangers become judges and juries. Judge Simpson's rule stops that chain before it starts. He's teaching both lawyers and viewers that privacy safeguards justice. Every responsible court should mirror this step. It might sound procedural, but in practice, it shields entire families from harassment. Ask yourself, should every state adopt a mandatory redaction policy for public case files? Because after this, it's hard to argue against it.
So that the contents of whatever, so if there were the letters, the redaction at the top of maybe name and certainly address and phone number and email would be done. So that it could be filed. If you have a question as to that or some issue, then certainly at any point you can bring that to the court's attention on that. I would also indicate that, and I understand Mr. Thomas's position in terms of his obligation, certainly to his client, and the like, but I think all of us as officers of the court are responsible for the operation of the court, the smooth operation of the court, and making sure that people are able to participate in our system without any fear or favor. So I do think there is an obligation on counsel to say something that doesn't obfuscate what one's primary objective may be. But I think that obligation does go there, and I would encourage counsel to talk to all of those individuals involved. I have, Mr. Thomas, had my staff send to your office a text message I am not, you emailed that with an attachment to it?
I did, sir.
All right. And I'm not gonna say the name of the person. This, as I look at it, this is alleged to have been sent to one of the victims. It is also alleged that the individual sending it is a member of your client's family in some way. So I doubt very much I'm going to do anything with that at this point in time. I want you to be aware of it. And I think, as I would say, with your obligations, I think that any member of the bar has its obligations to the court and our system, that you take some appropriate action potentially to address it with that person.
Here, the case edges into moral territory. Judge Simpson references a troubling text message, possibly from a relative of the defendant to one of the victims. He doesn't jump to conclusions, but he doesn't ignore it either. This is judicial composure at its finest, measured, transparent, and firm. What stands out is his respect for due process even in the face of potential threats. He invites the defense to handle it internally before the court steps in, reinforcing the idea that ethical responsibility starts with counsel. This is rare judicial restraint, firm without theatrics. The judge subtly reminds everyone that emotional loyalty never justifies reckless action. It's a quiet masterclass in leadership under tension. Viewers, do you think he's too cautious or perfectly balanced here? Comment your take, because this line between compassion and enforcement defines real justice.
Or, since the person is related to the defendant, as I'm to understand, maybe something from the defendant regarding that would also be helpful. But I will leave that to your discretion as to what to do with that. I mean, when I look at the contents, I could frankly take it in a way that it sort of means nothing. I could also take it in a way that it could be the beginnings of a threat. And so I just don't know what it means. I'm trying not to jump to any conclusion regarding that, but I think somebody may be lashing out, or the defendant. But sometimes you can have family members that lash out. It's not always necessarily in one's best interest. They're lashing out because of what they feel and what they believe. Okay, so what I will do, and I will leave it at this, counsel, I will, having heard from you, I will prepare an order. This has been a heck of a week, so I will try to get it out by Monday to counsel so that you have it, you can look at it, or actually Tuesday because of the holiday, and so that you can look at it.
By now, the courtroom feels drained but steady. Judge Simpson's tone shifts from tense to administrative, signaling closure after a volatile discussion. He promises a written order that will lock in these protections. It's easy to miss how critical that is. Verbal rulings fade, written orders last. The way he grounds his authority in paperwork may sound routine, but it's the spine of judicial integrity. Every safeguard he's built today will live on record, ensuring transparency and accountability even after emotions cool. This is the courtroom's version of long-term memory. It proves that justice isn't about who shouts loudest, it's about who documents best. For anyone following courtroom proceedings, this is the point to remember. Procedure is power. Without it, fairness collapses.
In the meantime, as I've indicated, the letters that were filed with the court are going to be placed in a confidential part of that file that no one will have access to. All right.
So
anything else?
Need to do
Go ahead.
with those letters in, Your Honor?
Pardon?
So you're saying I don't need to do anything else with those extra?
No, you don't need to do anything. We'll be good with that. The court has reviewed them. The court's made its ruling on the motion. I don't need that. They'll be part of the file, just not where someone can access.
All right.
Okay.
Yes, sir.
All right. Anything else from either side?
You have anything?
Your Honor, if we just let the prosecutor know, we will email him some additional information requests. We don't want to take up the court's time on that, but we will send out this week.
Well, I'm sure they'll look forward to getting it, see if they can respond.
Thank you, Your
All
Honor.
right, folks. Okay, thank you very much.
Thank you.
Thank you,
Judge.
Your Honor.
That concludes this matter. Thank you, folks, for bringing them up.
The hearing ends not with drama, but with discipline. Judge Simpson has turned a chaotic social media storm into an orderly, enforceable solution. Letters of support will remain confidential. Personal data will stay sealed. Both prosecution and defense agree. An uncommon harmony in any courtroom. This case demonstrates how quickly public emotion can threaten justice, and how vital calm leadership is in restoring it. The broader lesson is clear. Privacy is not weakness. It's a pillar of fairness. When courts adapt to protect participants from online hostility, they strengthen the system itself. If you found this case as revealing as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Your opinion fuels this channel's next deep dive into the intersection of law, ethics, and digital culture.